Indian Contract Act of 1872. This act is a very exhaustive and comprehensive act which is divided into roughly 11 chapters. And the two chapters, that is chapter 7 and chapter 11. Chapter 7, that is Sale of Goods Act, and chapter 11, that is Indian Partnership Act, have been repealed. And there have been two new acts have been flown out of those two chapters. So the vision of the framers, we can say the Britishers, who had framed this law, is very exhaustive and very apt to the situation, and it is in force for more than 150 years. So the person who can contract in a civil during any civil litigation, a person who approaches the court or who comes to the court should come with a clean hands. That means he should be very fair enough, honest, and a law-abiding citizen, and he should be a good person to avail the to knock the civil jurisdiction or the civil court of law. So the first today's topic is Indian Contract Act. How it starts? It starts with an offer. An offer should be to do a thing or abstain from doing a thing. And he should communicate to the acceptor. Simply keeping it in the mind as an offer, as a promisor, that is not sufficient. It should communicate to the offeror or the promisee, where the promisee receives the such a offer is called a promisee. So the two persons is called, one is the promiser, the person who promises, and the promisee, the person who receives it. So these two persons are the vital person for the contract, for anything. So this proposal, to whom it should go? When a promisee accepts this for a consideration, it is called consideration for the contract. If the promises are in two or three, for the two on the same subject, it is called as the reciprocal promises. So an agreement which is not enforceable at law is called as a void agreement. And an agreement which is enforceable, called as a contract, an agreement is called as a contract which is enforceable at law. So an agreement which is enforceable by law at the option of one or more other parties is called as a voidable contract. So we have seen offer, acceptance, consideration, void contract, and voidable contract. So what are the essentials of the valid contractor? One is the promiser, promisee, consideration, agreement, void agreement, contract, voidable contract. A contract subsequent operation by law is called, which becomes unenforceable. A contract by subsequent operation of law becomes void, then it ceases to be unenforceable. So now, how the revocation communication is made. communication is complete when when the promisor puts the process of transmission, puts into the process of transmission. It is called a communication. That means as regards the promisor, he has put the process of offer in a transmission mode, then his job is complete. It is as regards the promisor is concerned. As regards the when it is completed, this process of transmission will be completed when it reaches the promisee. That means the person to whom the offer has been made. So the communication is complete from the process, from the angle of the promisor when he puts into transmission, and it is complete when it reaches to the promisee, and in the promisee when he puts into the same manner and it is conveyed to the promisor. So now we'll go the chapter of revocation. Why revocation is come means after the promisee, if he has transmitted the offer or acceptance, the revocation, there are two people, as they are both are natural, they may have different thoughts and they may think it may be this contract of offer or acceptance, if it is revoked, it feels it is better for them. So when it is to be, revocation can be made. How? Revocation can be made by communication. When the promisor or promisee communicates or informs the promisor that I am not able to continue with the present contract, that means the revocation is complete. First thing. The second thing is by the lapse of time. If a promisor stipulates that within a week the promisee should communicate his acceptance, then if that 7 days time is elapsed, the promisee does not communicate the acceptance, then the operation of time, that is the lapse of time, the offer promisor, that is the offer is revoked, or acceptance as to the acceptor, as to the promisee, when it is complete. It is complete when before the promisor receives the information about the acceptance, the promisee can revoke his proposition. Both have the same method of accepting or revoking. The fourth point comes when it is revoked again, once again. Then when this revocation clause starts with the death of the promisor, or he has become an insolvent, or has become an insane person, or by the subsequent operation of law. So these are all the methods where the revocation comes into the practice. Now the questions. Now the second acceptance is how the acceptance should, when the acceptance should be absolute. The acceptance should be absolute. That means the promisee should accept the offer in an absolute mode. That means he should not add any conditions for the conditions which are stipulated by the promisor. It should be accepted as per the terms of the offer. If any conditions are added, that is not a proper acceptance. It should be absolute and in the same manner. So the promisee should not enforce any conditions for the acceptance, or he say that this contract or this offer should be in the same manner which I am telling, that the promisee is telling. So this is the other situation where the acceptance should be absolute. How? Again, the question is how the promises a promise may be expressed or implied. Expressed means by the spoken words, or implied means other than words, which may be as per the terms of the offer. Now we come to the section 10 of the Indian Contract Act. This is a very, very important, vital section where the entire Contract Act is depending on this section. The first is free consent of the parties. The consent should be free. It should not be biased. It should not be driven by coercion, undue influence, fraud, or misrepresentation. So any of these four elements should not drive the consent for the parties to the contract. And it should be free consent in whatsoever manner. The next comes consideration. Lawful consideration. The consideration should be very, very, very lawful. Either it may be expressed or in the manner it may be in terms of the services as per the offer. And the object also should be lawful. As regards the consideration, the object also should be lawful, and it should not be expressly declared as void. Such a contract or such promise made by the promiser should not be against the, it should not be expressly declared as void. It should not be against the law. It is enforceable as law. Now, what is the competency of come to a contract? One is who has attained the age of majority, and he should have a sound mind, and he should not be disqualified to enter into contract by operation of any law. That means an insolvent or some other happenings which is not specified clearly, but the competency of the persons is decided in dealing with the contract. Now, what is sound mind? Sound mind is who is capable of coming to a rational judgment. It is called as a sound mind. So any person who is suffering with unsoundness prematurely or intermittently, he can enter into a contract. But who is suffering with that is meeting of minds. The mind of the proposer and the mind of the promisee should be equal, balanced in all respects, and it should be in the same mode of transmission, same mode of acceptance, and then the contract will flow out of such acceptance, offer and acceptance of the promiser and the promisee. This is called about the free consent. What is a free consent? Free consent is definitely it should be a nearer person under threat or coerce him or put him under any other bodily harm or damage mode, then that consent obtained freely is a very essential vital element to form a contract. Now the other questions which the consent is said to be free when it is not guided by section 15, 16, 17 and 18. They are called coercion, fraud or misrepresentation. So these are the four sections which are expressly dealt in the Contract Act for and now the question, the next aspect comes about the mistake of of law. Mistake of law is forbidden by law. And the other is one is forbidden by law. Other point where the mistake comes is that it is if it is followed, or if this contract had been come into existence, if it forfeits the provisions of the law, then it is also called as a mistake of law. So mistake of law and forbidden by law, and which is against the law established. So these are the two aspects of the mistakes which we need to be considered when at the time of entering into a contract. So again, what about the what is forbidden by law? Forbidden by law is it involves or implies injury to the person, putting any person under injury or under threat, or subsequently when a court comes to a decision that this act is forbidden by law, then such is called as provisions which are forbidden by law. So now that next comes is void agreements. These are called void agreements is because when the consideration itself and the objects of the contract itself is unlawful in part or full, then it is a void agreements. Now we'll come to about the agreements without considerations. There may be a situation where there are agreements, there will not be any consideration at all. That is, we will see in donor-donee relationship, where a donor expresses his willingness to donate or to give or to part with his wealth to the donee, and the donee accepting this as a proposal and basing on the assumptions, on the promises, affirmations given by the donor, if he acts on it, then this is a valid contract, even though there is no consideration passes on from the donee to the donor. So donor-donee relationship, we will find this situation where there is no consideration at all. On what are the void? There are other agreements. What are the other agreements which are void? Is that agreement in restraint of a marriage. If I say, if a person agrees that to another person that you should not marry some other girl, then it is a void agreement. Even if that girl marries some other person, then also it makes no sense. And there is an agreement in restraint of a marrying of two people is a void agreement. This has no sanctity at law and it cannot be enforced. And other agreement, there is another agreement in restraint of a trade is also void. So this is a situation where a trade, where the offer even though there is a contract in restraint of trade, that is also a what is it called? In restraint of, it is called a void agreement. So now we have seen void agreements, voidable agreements. Now we'll go to the there are some other agreements which are barred by the operation of law. If I say section 294A of Indian Penal Code, there cannot be an agreement legalizing an unlawful act. If you say that horse trading is there, horse trading is barred by the law itself. That cannot be legalized. So in this situation, 294A. These type of agreements defeating the provisions of law which are existing in our country, they are also void agreements and that cannot be enforced. Now, the next comes is contingent contracts. These contracts are entered into by the promisor and promisee on happening of an event. If I say, if the offer is there that if any loss is covered or any loss if a person sustains on the happening of an event, that is called, if we say the house property is gutted under fire. So the offer, the condition is that the event is happened. What is that event? The happening of a fire of a building that has been happened. Now the person, the acceptor, the promisee who has had a contract with him, in that situation also, this contract is a valid and agreement which is enforceable at law. Now the next chapter comes about the chapter 4. That is the performance of the contract. What is the performance? Obligations on both the parties, that is the promisor and the promisee, to fulfill their offer and the accepted principles, and they have to complete the contract, sit together and complete the contract. That is the first permanent obligation, bounded duty on acceptance on coming to a contract. In that, on such a case, the performance, the contract has to be done and fulfilled. Now, the next comes is the offeree dies or the offerer dies. The promisor or promisee has died or any one of them has died. Then the contract becomes unenforceable and they cannot be enforced in the court of law. That means this contract cannot be performed. So the question is, the next comes is refusal to accept the offer of the performance. What will happen? The refusal, it should be unconditional in that it must be made at the same mode. The offeree should accept the communicate the performance, that it should be unconditional and it must be in the same mode as the promisor stipulates. If I say it should come by mail, the acceptance should come by mail, then the mail should go, the mail from the promisee should go to the promisor in the same mode of email itself, and it should be in the stipulated time. If I say 1 week is stipulated for you to accept the proposal, that means the promisee should accept the proposal within a week and he should transmit it in the same mode as in the proposal. So the next comes is, what should be the reasonable time? If nothing is stipulated, no time bar is stipulated, and what should be the reasonable time? Reasonable time should be a minimum of 1 week to 10 days and not more than that. So this is the about the performance of the contract and how it is to be transmitted and transmission. Now, time is the essence of the contract. It should, as I said earlier, the time is very, very important in a contract act, and to come in two parties to come into an obligation of contract in binding obligation. So the time should be very, very reasonable, and it should be within the time prescribed by the offerer and by the promisor, and it should be transmitted to the promisor within that time only. As per section 58 of the Contract Act, any agreement to do an act which is impossible in itself is an void agreement. It cannot be performed. If I say that I can bring sea to Hyderabad, from Bombay to Hyderabad, it is not possible. These sort of agreements are not at all enforceable and it cannot be performed. So this is the thing about now we'll come up to the chapter 5, quasi-contracts. Quasi-contract is a peculiar situation where unknowingly or knowingly two persons come into a contract with each other. What are the situations which comes under the quasi-contract is that claim for the necessaries supplied to a minor. So minor is there, he has a property, and the supplier is there, he is supplying to the minor. Though minor, he is not a competent person to come into a contract with any third person, but in this case where the necessaries have been supplied to the minor by a supplier, by the known supplier or unknown supplier, whoever may be, when that supplier or that person can recover the cost of the minor necessaries from the minor's property. This is a quasi-contract where there is no relationship of contract, but the contract is subsisting between both of them. Obligations of the persons enjoying benefit of a non-gratuitous act. If this is a situation where a person mistakenly delivers certain goods to another person who thinks to be the person who has to receive. If I say the person has delivered goods to A instead of B, then A accepts that goods and he uses and consumes the goods. Now the person who has supplied he has every right to recover from A, though he is not the person to be received, as he has consumed the goods, knowing fully well that it is not the particular person to whom the goods have been to be delivered. This is the situation where the gratuitous quasi-contract relationship establishes. Now, in this situation, now we also find a situation where the finder of the lost goods. This is a very important thing. Finder of the lost goods. See, we are not bound, we are not at all authorized to touch or appropriate the goods which do not belong to us. We are not authorized to touch them, or else we should not appropriate for ourselves. These are all called as finder of the lost goods. If I lost a person on a transport, the person who has seen it, who had received it, the purse, his bounden duty is to trace me who is the original person and hand it over back to him. If this is not the case, he should hand over to the nearest police station. If this is also not possible, he should advertise in the newspaper or in the TV channel, whatever it is. He has every bounded duty to trace the person to whom the goods belong. If that person fails in complying in any of those situations, then he is if the person is able to transfer to where the promisor is able to locate where the goods are lying, to whom the goods are lying, then in such a cases, the promisor has every right to get the goods back to him. So this is all about the finder of the lost goods. Yes, sir, Keshav sir. Anything to be added?
Nothing, sir. Sir, you can summarize as soon as possible. Time is officially over. So, but sir, you can summarize definitely.
Okay.
If you want.
Oh, fine. Okay. Now we'll come up to as Keshav sir has said, the time is very limited. We have only half an hour. Now I'll come to the breach of contract, chapter 6. What is a breach of contract? If anyone goes away or withdraws back from the contractual obligations, then it is called as a breach. A breach has been committed. So what are the options available to the offerer or the promisee? He can resign the contract. He can approach the appropriate court of law and obtain the what he can obtain for the after the consequences of the breach of contract or the quantum of merit. He can the damage, he can quantum merit, restitution of the contract, and he can also claim the damages for the consequences of the breach of contract. This is about the chapter 6 about the breach of contract. Now we'll go about the indemnity and guarantee. This is a very, we'll go very fast, not much to be indemnity, guarantee, and pledge. All these are bailment and pledge. These are all similar. These two chapters are almost similar to each other. Indemnity is the guarantee of the where a borrower, where a bank usually comes ask for a guarantor who is liable, who can pay repay if you cannot pay. That means a surety. He is called as a surety. One we call it as indemnity, guarantor and indemnity, and two persons: principal, borrower, and the surety. Three persons have come here. The principal is the banker, borrower is the person to whom the amount is given, and the surety is the third person who is standing as a surety in case of any default made by the borrower. He will come in place of the borrower and pay back the amount. This is called about the indemnity, guarantee, and the next comes about the now how the surety, what will happen if the surety pays. When the surety pay back the total amount of the borrower, then the surety has every right as a principal to get the money from the borrower, borrower who has been who has not fulfilled his part of obligation. Now there comes with the bailment. What is a bailment? Bailment is called as a bailer, bailee, and bailment. There are three aspects in this chapter: bailer, bailee, and bailment. What is a bailment? If we have, see, we are all advocates, we have courts. When we give a court to a dry cleaning, that is called a bailment. The court is the bailment. The bailer is the person to whom the bailer is the person who gives, and the bailee is the person who receives. His duty is to clean the court and give it back to the bailer. If at all any damage is done, in them the bailee is liable to pay total amount of the cost, or as per consequences are there, he has to fulfill the, he has to face it and complete the that part of the bailment and the person who, the bailment is also the same and the pledge is also the same. The duty, honest duty of the pani or pani is that he has to take total care of the product for whom he has for which the ornament has been pledged. If I say the gold ring is pledged, he has to take proper care in protecting the ornament, and he has to give it back to the pani or paner in the same mode and the same condition as he had given in the at the time of the execution of the contract.
So, sir, there are few questions that I have received, and we'll have a short question and answer round. So, first question is from Sanjeev. Sanjeev has asked that, sir, if Chapter 7 and 11 of Contract Act, I assume, have been repealed, then what are the acts called? Newly written. Sanjeev, do you want to ask this question yourself?
He can ask directly, or he can post it.
Sir, you said
Yes,
chapter 11 and 7 have been repealed. So
repeal, yes.
So what are they called now? So then there must be some newly acts which must be written instead of those chapters. New chapters must be written. So can we read it on net? So what should we type on the Google or on the net? So if I want to read the newly written chapters instead of them, which have been repealed.
Sale of Goods Act, it is same as it is. Chapter 7 is called a Sale of Goods Act. If you type it in the same manner, you will get it.
But we have to write some amended Sale of Good Acts. Amended the word.
It has been repealed. A new act has come into the force. The old act has gone. The chapter entirely is gone. It is not. You will not find any place in this Contract Act, but in the new act it will be there.
So which year the new act was passed, sir? In which year the new act was passed?
That I need to check, sir. And the Partnership Act is there. Chapter 11. I'll let you know of partnership 239 to 266. This has also has been repealed. A new act has come into force.
So if we simply type Sale of
Indian
Goods Act and
Partnership Act.
Partnership Act, sir, we'll get the new act, no, sir?
Yes, Indian Partnership Act. It is there already in the net.
Okay, so if we type them, so we'll get the new act, not the repealed one.
No, you will get the new act.
Acha, and sir, in the Sale of Goods Act, sir, from which section to which section has been repealed particularly?
Section 76 to 123 of the Contract Act.
Acha, they have been changed.
Yes, sir.
So automatically,
Yes,
if we type, automatically the new acts will come.
Yes, Sale of Goods Act will come on the internet.
Acha, sir, but it will be written amended Sale of Goods Act or amended.
No, it will be it will not come like that. The Sale of Goods Act, that's it.
Okay.
The Indian Partnership Act.
Acha, sir, but if
Like
we
that, it
knew
will
the
come
year,
on.
na, sir, then we wouldn't be confused. Sir, suppose the old act comes, sir, then we'll be in trouble. If we get
No, old act will not be appear in the even in the Bare Act also of the Indian Contract Act. You will not see the provisions of the Sale of Goods Act section 76 to 123. They are not at all visible. They are not coming in the book at all.
So directly after 75, the 76 will be some other act, not this repealed act.
After 75, you will have section 124
Acha,
directly.
Okay.
Yes.
And similarly in Partnership Act 239, say 266, that will not appear. After that,
That-
267 will appear.
Yes.
Similarly
After,
on the net, sir. Similarly on the net.
yes. Yes.
Okay, sir. Thank you, sir. Thank you, sir.
Yeah. Okay. Yes, sir. Sanjeev sir.
Yes, sir.
Hear me anymore?
Nice, sir. Thanks.
Okay. Yeah. Shall I continue, sir? Only
Sir,
very small.
definitely, sir. Any doubts? Sir, definitely, sir. Please. Any questions? Please, anyone feel free to ask. Sir. Otherwise, you may please continue.
Agency is the last chapter where the Indian Contract Act ends. What is agency? Agency is there are two persons. A person, I am capable, I'm having money, but I don't have time to do some act. Then I appoint an agent, and that agent will work as per the terms and conditions of the appointment. If he has exceeded that terms and conditions, then I have no duty to ratify it. So in an agency, the principal and agent, two persons are there, and there should be a ratification clause. Ratification clause means that anything done by the agent is itself done by me. That is the ratification. That is the assumption made in an agency act. Now, the principal, the persons who are eligible to contract are also eligible to act as a principal or act as an agent. These are the other two aspects of the Agency Act, and agency are covered under Chapter 10 of the Indian Contract Act. No consideration is necessary in the contract of agency. This is a very vital important situation where consideration is not at all mentioned, that a consideration should pass from the principal to agent. That is not there in this chapter at all. The next comes how the authority is given. The authority is given by the principal to the agent, which may be expressed or by the implied. It may be expressed in terms of words or implied by the actions of the principal and the agent. These are the other things. And other sub-agents. Does the agent have a power to appoint sub-agent? This is a very important situation where a maximum non-delegated. That option arose in the company cases, especially in 138 cases, 138 section Negotiable Instruments Act case, where the company is authorized by the shareholders to run the company. So when the shareholders are appointing some persons to run a company, does the persons who are appointed at a general meeting, which we say the director or managing director, do they have further power to appoint some other person to represent a company in a court of law? So this maxim was strictly dealt in the situation where the Negotiable Instruments Act of cases have been filed by the companies, delegates plus non-delegate. That means the sub-agent does not have further power, any power to subdelegate or to delegate or to appoint some other agents as sub-agents to perform a contract. So these are the situations. And about the agency. Now, revocation of the authority. How the agency is terminated. The agency may be terminated prematurely when the agent or the principal becomes unsound or incapacity of to perform a contract. These are the situations where the agency can be revoked, revocation revoked. Yeah. So these are the other situations. There are other situations also where the agent is primarily duty is to safeguard the interest of the principal. He cannot go against the interest of the principal. He has to safeguard. He has to work. He has to do as per the act, as per the orders or dictum of the principal. This is the situation under the Agency Act. So, any more questions? You please ask me or message me.
I want to convey from everyone regard the many thanks for conducting this class today in the manner that you've done it, and for the perseverance of completing the entire course material that you have prepared. So we're really grateful to you for that.